What is constructive dismissal? In layman's, without having to go legal on it, constructive dismissal might be said it's a situation whereby an employer tries to frustrate an employee in order for the employee to resign and leave the workplace. So there could be a lot of reasons why the employer may want to frustrate an employee to leave the workplace. So, hello viewers, my name is Bianca. Let's talk. So today on our talk conversation, we are going to look into a labor topic in relation with constructive dismissal. Now, before I am to go in details to explain on what and what does not amount to constructive dismissal, I specifically chose this topic as my first topic because of a concern that was brought to my attention a few days ago while I'm still here in Germany by a person that I don't know of. It was just an ordinary question to say, look, this is how I've been treated at work. I feel I'm being constructively dismissed. Now, for those who are not labor experts, even some lawyers, they may get confused between constructive dismissal while you are still in employment and unfair labor practice. Because sometimes you may find the two may work hand in hand, leading into the other. What am I trying to talk about? You will find maybe sometimes the employer trying to frustrate you in order to leave. They may change certain terms and conditions of employment, which already that hand falls under unfair labor practice. Them changing it. You can take a step and seek recourse in that line. However, that's a topic for another discussion. But through this treatment that they've given you, changing your terms and conditions of employment may lead into an employee being frustrated and resign when he or she didn't have an intention to resign. Now, with constructive dismissal, we put aside the issue of unfair labor practice because that's a topic for another day, like they were indicated it. With constructive dismissal, again, in order for it to be there, you first don't need to be a subcontractor doing some construction work, and then today they come and tell you are going to work somewhere else, then you say, I'm constructively dismissed. It doesn't work that way. First and foremost, there's need to establish employer-employees relationship. Once that has been established, what changes have been made from the time you have been employed? What kind of treatment has been made? How are you frustrated? Because the frustration must come from the company at large. The company needs to frustrate an employee in order for the employee to be forced into resigning. Now, also even into be forced to resigning, the resigning should indicate to say, okay, I'm resigning because I cannot take it anymore with the work environment because it's too toxic. I do not want to resign, but I'm resigning because of the ill treatment that I'm receiving. And then from there onwards, you can take a further step if you want to like at the Office of the Labor Commissioner and so forth. Again, that's something we'll discuss another day, one step at a time. Now, with constructive dismissal while you are at the workplace, the treatments may differ. Maybe you may be degraded, maybe you may be demoted, maybe you may be treated ill and all this thing has to last for a certain period of time. The Labor Act doesn't precisely indicate to say for 6 months, for 5 months, you need to be ill treated. You need to feel it yourself that you cannot take it anymore. But the point is, you need first to be treated ill or in a manner that you feel it's not proper, or any other reasonable person into your position would not take it anymore. And that treatment has prompted you into believing that the employer is indirectly trying to dismiss you. Hence the constructive dismissal coming in place. So the treatment ranges from one to another. It may be different things. I gave a good example, for example, on changing the terms and conditions of your employment, or it may be an issue of all of a sudden they are degrading you or bringing you down or demoting you, or from 1 minute to another you are treated different from the rest, and then on that basis you feel like you can no longer work peaceful with them until that specific issue is resolved on the treatment basis. Now, to move further, in such a case now, if that has been established to say the treatment is not proper, and you feel like indirectly you are being dismissed, but they are not telling you that they are dismissing you, they just want to push you into resigning or frustrate you into resigning. So in such a situation, you find an employee is now expected to tender in a resignation. In the resignation you indicate, but again, before we go there, you should have been able to address the issues with the company or the supervisors, and nothing is being done. It could be via email. I would always advise my clients, like, you do via email or via in writing, because it can back you up tomorrow. By word of mouth, tomorrow you can say, no, but I informed my supervisor. And if it's the supervisor that is ill-treating you, chances of the supervisor coming up and say, oh no, yeah, I was told, are very, very slim. So the best is to reduce in writing so that you can have proof to show that I had brought this to the attention of my supervisor and it was ignored. So you can write and say, look, I see you've changed my terms and condition of employment. I'm no longer coming to work at 8. You're changing it to 7 o'clock, but that's not a big deal. It's just an example I'm giving. Or the good practical example I can give is, you've changed my job description overnight. You know, you want me to do editorial work, for example, when in actual facts I'm supposed to be just doing HR. The department that you are taking me to, it's too intense for me to be able to give proper report or good work, skills, to show your work skills at the end of the day. And you feel because of that change, it's not reflecting well on your job performances, so much that at the end of the day, again, you might be charged for poor work performance, and you are so concerned in that direction. So there are a lot of things that you need to take into consideration, and they should happen for a period of time. And you should be able to communicate to your employers and say, look, there's this concern that I'm having, and so far I've been bringing it to your attention. The environment, it's indeed becoming toxic. It's important to establish that the environment is toxic for an employee to work because of the ill treatment that an employee is getting. After that has been done, emails or letters have been given to the employers, there is no change that is happening, then you resign. And when you resign, in your resignation, you indicate, I do not want to resign. Emphasize on that part. I do not want to resign, but because of the ill treatment that I'm getting at the workplace, the environment is so toxic, I'm forced to resign. But I do not want to do that. You give them a notice period in terms of your contract of employment so that you don't make a mistake on you as well, breaching part of your terms and condition of employment. So once you give them a notice, okay, I'm serving you a notice, whether it's a week, depends on how long you've worked, or it's a month and so forth. And then thereafter, if there is nothing that they're doing and the time comes for the notice period that you've given to come to an end, if you want to refer a dispute to the Office of the Labour Commissioner, then you refer that dispute of constructive dismissal. And then you can now indicate, these are the grounds on how I was constructively dismissed. So at the Office of the Labour Commissioner, you'll find they'll give you certain forms to fill in, you prepare your summary, you give a brief background, and so forth, and then you are going to go through the process of conciliation and arbitration. Again, that is going to be a discussion for another day. But today, in short, I just wanted to bring awareness to employees and to employers as well. You need to be careful on how you treat certain employees, because certain conduct may come innocently but may be misinterpreted to mean you are indirectly trying to dismiss an employee by forcing them to resign. So this video clip is not just for employees, it's also for employers. Anyone of the two can take it and use it to their advantage and see what they or he or she is doing wrong and try to change it to avoid a dispute being brought to the Office of the Labour Commissioner, which is the first instant court for labour matters, and you end up spending a lot of money unnecessarily when you're not even supposed to do that. So there are a lot of things that I can give examples to, but this is just my first video, and I hope you like it. I hope you learn something. In order for you to learn more about this, subscribe to my channel, hit the notification button so that whenever I post anything every week, you are able to receive a notification. Leave your comment, let me know what topic you would want me to discuss in labour matters. And maybe just in brief, I have a vast experience in labour matters in Namibia, to be specific. I've worked in government under Ministry of Labour, Office of the Labour Commissioner to be precise. There I was a supervisor, as a chief arbitrator, and from there I went to work at two big law firms also which specialize in labour matters, where I learned a lot of things again further. So my experience is very vast when it comes to labour matters, and also I was a lecturer before. I lectured again in labour matters, so it's not just on the theoretical part I know. I also know on the practical part of it, the whole process from the company stage, disciplinary stage, Office of the Labour Commissioner stage, Labour Court stage, including the Supreme Court stage. So should you want me to discuss a certain topic just in brief, leave your comment, then let me understand and look into what you are looking for. And all I can say is thank you.